Welcome to Community Legal Education Association's Legal Information for Tenants in Manitoba video series. This video is about security deposit disputes. This video was produced by Community Legal Education Association Manitoba, or CLEA, with funding provided by Justice Canada. CLEA is located in Winnipeg, Manitoba on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and the traditional homeland of the Métis people. Our water is sourced from Shoal Lake 40 First Nation. We acknowledge that much harm was done in the past and continues to be done. Therefore, we dedicate ourselves to moving forward in the spirit of reconciliation. This video contains information about Manitoba laws and is only intended for Manitoba residents. This video contains general legal information only and not specific legal advice. For legal advice about your specific situation, speak to a lawyer. Tenants are usually asked to pay certain deposits to the landlord when they begin renting. These deposits are held by the landlord throughout the tenancy and can be used to pay for damages to the unit or money owed to the landlord when the tenant moves out. Most tenants are asked to provide a security deposit. This is also sometimes called a damage deposit. The amount is set by law as 1/2 of the monthly rent. So, if your rent is $900 per month, the maximum security deposit the landlord could ask you for would be $450. The landlord can also ask you for a deposit of up to 1 month's rent if you have a pet. This is called a pet damage deposit. It does not apply to service animals. If you rely on a service animal, your landlord cannot charge a pet damage deposit for it. In a building that provides tenant services, a tenant services security deposit can only be up to 1/2 of the monthly tenant services charge. Tenant services include meals or light housekeeping. The standard residential tenancy agreement form lists these deposits and when they were received. A landlord must give a tenant either this form or a receipt showing payment of any of these deposits. A landlord can't ask for a deposit unless they told the tenant that a deposit is required before the tenant signed the tenancy agreement, or in the case of a pet deposit, before they allowed the tenant to get a pet. A landlord also cannot require payment of any of these deposits until the landlord and tenant have signed the tenancy agreement. This means that if you are applying for a new rental unit, the landlord cannot ask you to pay a deposit when you submit your application. A rental unit condition report is a description of the condition of a rental unit when the tenant moves in and out. Filling in these reports is not required by law unless either the landlord or tenant asks for it to be done. However, it is a good idea for tenants to get a condition report when they move in because it documents whether damage in the unit was already there when the tenant moved in. This can protect the tenant from a future claim by the landlord. In the residential tenancies regulation, there is a set form for a condition report. Some landlords also create their own condition reports. A landlord or a tenant may also ask that a condition report be completed if a tenant moves a pet into the unit during a tenancy. A landlord and tenant should carefully go through the unit together. Any damages should be written down on the form. The landlord and tenant should sign and date the condition report, and each should keep a copy. It is also a good idea to take photos or videos of the items in the report, especially if there is existing damage. The condition report form is very detailed and has codes for the condition of items in each room. For example, refrigerator, crisper, ice trays, and freezer. Write down whether everything in the unit works properly as well, including appliances, plumbing, heating and cooling systems, and fans. Make sure the windows open and close. When you move out, damages that were not there when you moved in should be listed on the condition report. You and the landlord should date and sign this last report and each keep a copy. You and the landlord can also use a condition report to make an agreement about the refund of a deposit. You must clean your unit thoroughly when your tenancy ends. This includes vacuuming, cleaning marks off the walls, defrosting the freezer, cleaning the appliances, including the refrigerator and oven, and wiping the cupboards and drawers and fixtures so that everything is free from dust and dirt. If your unit isn't left clean and the landlord has to hire cleaners, they can charge you an hourly rate, and the cost will be applied against your security deposit. At the end of a tenancy, the landlord generally must return all deposits to the tenant plus interest within 14 days of the end of the tenancy. A tenant can ask for the security deposit to be applied to the last month's rent, but the landlord must agree to this in writing. The landlord also has the right to make a claim against deposits the tenant has paid. These claims can be for things like unpaid rent, damage to the unit, and extraordinary cleaning costs. Some examples of things the landlord could make a claim for include things that the landlord has to repair, like broken countertops, things the landlord has to replace, like locks if the tenant didn't return all the keys, utility bills that the tenant was supposed to pay but didn't, lost rent, for example, if the tenant did not provide the proper amount of notice before moving out or refused to allow the landlord in the unit to show it to possible new tenants, rent discounts, if the tenant did not meet the conditions for their rent discount. For example, if a rent discount was given only if the rent was always paid on time, but the tenant paid rent late. To make a claim against a deposit, the landlord needs to send a notice to the tenant within 28 days of the tenancy ending. If the amount of the landlord's claim is less than the tenant's deposit, the landlord must return the leftover funds to the tenant. If the tenant and landlord cannot agree on the charge against the deposit or the amount owed, either party can ask the Residential Tenancies Branch to decide. The Residential Tenancies Branch is a government body that provides information to both tenants and landlords about their rights and obligations. The Residential Tenancies Branch also investigates matters between tenants and landlords. The branch will first try to settle the matter through mediation. If this is not successful, an officer will decide either by reviewing the information or holding a hearing. It is important that tenants keep records about their tenancy and anything that could come up in mediation or at a hearing later on if there is a dispute about the deposit. Some examples of evidence that can be used at a hearing are condition reports, tenancy agreements, receipts and invoices, photos, notices, USBs, DVDs, and written statements from witnesses who can't attend the hearing. For more information, visit the Community Legal Education Association's website at www.communitylegal.mb.ca.